Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 20-1277 et al. Ameren Illinois Company, doing business as Ameren Illinois et al. Petitioners versus Federal Energy Regulatory Commission. Settling for the petitioners, Ms. Chu for the respondents.
Mr. Silberman, proceed when you're ready.
Good morning, Misha Salin for Ameren. I'd like to reserve 3 minutes for rebuttal. For over 10 years, Ameren spent millions of dollars on transmission materials and costs. These are things like spools of wire, poles, things of that sort. It is undisputed that that category of materials is recoverable under the Federal Power Act and under FERC policy, because of course, those expenditures are necessary so that customers get reliable energy transmitted through the transmission line. Now, Ameren, during this period, following standard industry practice, reported all of those costs and materials on line 8 of page 227 of Form 1. Of course, that made a lot of sense because that is the only line that says that identifies functionalization of transmission costs. Then in 2018, FERC changed how it wanted the form filled out, said that all those costs that are construction need to be put on line 5 only. Now, we have no particular problem with putting those costs where FERC wants them now going forward, even though that makes the form kind of a mess. You know, it's their form. We're happy to do it. But the problem is that then they ordered 10 years of retroactive refunds for expenditures that are unquestionably prudent, recoverable under the Federal Power Act and FERC policy. Now, in our brief, we talked about multiple independent reasons why this court should vacate the orders on review. But as we pointed out in our reply brief, the most straightforward way for this court to dispose of this case is apply this court's decisions in Code Gateway, Town of Concord, Gulf Power, and say that FERC entirely failed to exercise its discretion in determining whether in good conscience and equity there should be refunds here. Now, again, the legal test that this court has laid out in those cases are articulated for retroactive refunds, which is an equitable remedy in the nature of disgorgement, is in good conscience and in equity. Can the utility keep that money? Would the utility get some sort of windfall? And
can I ask you about the windfall?
Yes, Your Honor.
That seems like it's a key idea in all of these cases. So on one level, it seems your position has a lot of force. This seems hyper-technical. We're talking about lines on a form. And so there's no windfall relative to what might be thought a just and reasonable rate under the statute.
That's right.
But in the context of the filed rate doctrine, why shouldn't we think of windfall as windfall meaning something above and beyond the filed rate? And by that measure, there is a windfall because your tariff didn't cover line 5.
The nature of an equitable inquiry is you look beyond form and you look at substance. This court certainly found an error in Coke Gateway. That was an error, and this court made clear in Coke Gateway and those other cases that a finding of an error, which by the way, we dispute that we made an error, but a finding of an error is the beginning of the inquiry. It is not the end of the inquiry. In fact, there was an argument in Town of Concord where FERC was on the other side. The towns there were arguing FERC's got to give a retroactive refund automatically. It has no statute and FERC and it has no discretion. And FERC argued forcefully, no, we have discretion. There's no automatic refunds. We need to do an equitable analysis. Well, they won that argument and they can't run away from it now. They have discretion and they have to look into the substance. Were these recoverable costs as a matter of the Federal Power Act and FERC policy? Yes, that's undisputed here.
Okay, but where that argument seems to point to is that the violation of the filed rate won't produce a refund if the amount is just and reasonable under the statute.
I think that as a general matter, correct, but there could be other.
Maybe, but that's a pretty broad principle. It seems like the default rule is in the run of the mine case, if you have a violation of the filed rate doctrine, you get a refund.
I mean, that's certainly not what Town of Concord said. I think that was kind of the core submission of the towns in Town of Concord, that they're just like that. And FERC argued forcefully the other way. They said it's the beginning of the inquiry. You got to have an error. Retroactive refunds. This is disgorgement. It's a big deal. You're clawing money back. So the way that this court's case law articulates it with respect is not like that, is that there has to be an equitable analysis.
But you don't have a huge number of cases where there's a violation but no refund. You have Coke, you have Gulf, Concord.
Yeah, and Your Honor, I think this case is on all fours with Coke and with Gulf Power. And, we made a big deal out of Coke in our opening brief. I didn't even see my friends in FERC in their response brief or the interveners even attempt to distinguish that case. And I think that case is enough. But I will say that there could be other considerations beyond fair, just, and reasonable that could be taken into account in equitable balance.
So what can you give me besides there is a violation of the filed rate doctrine, but there is nothing that would make this unjust or unreasonable under the statute? What else distinguishes your case?
I think if there was some sort of real carelessness by the utility was doing something very different from what everyone else is doing, it was a really unreasonable reading of the form. If there was some sort of allegation that they were doing is trying to hide the ball in some way to avoid an audit. But here we're doing like normal things. 20 other MISO transmission lines were doing it. All these big other utilities were doing it. I think it's the best reading of the form, but at least it was a very reasonable one.
How would we distinguish, were we to hold that FERC failed to appropriately exercise its equitable discretion? How do we distinguish the Duke decision? Because it seems like this is really on all fours with the analysis there.
Well, Duke Energy Progress was obviously the decision that started this problem. The issue there was that Duke Energy Progress never even petitioned for reconsideration or came to this court because they came to a negotiated resolution with their municipal customers. So the fact that Duke made a separate piece, and I don't know what the economics were or the business relations were, certainly can't be held against us to cause us to have to give up $11 million of prudently expended materials and costs.
Prudently expended, but I take the commission's position to be prudently expended in part on construction. And as you well know, construction is a sort of a very different kind of expenditure from operations and maintenance. And so the fact that there's a line there, I mean, the physical ambiguity of the chart is only part of the picture. If you're operating a business in which construction is typically dealt with quite differently from operations and maintenance, that alone seems to me to be quite a practical guide in reading and filling out a form like this.
I mean, I don't think there's anything in the record here to suggest that the difference between construction and maintenance in the transmission realm is more meaningful than the difference between production, transmission, and distribution. In fact, what do you need to buy in order to do a construction project? It's the same kind of stuff, spools of cable, poles that you need to do an expansion. You have a storm that knocks out a portion of your line, you're going to need to rebuild that line. That could be seen in construction, that can be seen as maintenance.
But for rate purposes and for understanding a filed rate, isn't it quite different when there's a discussion of sort of what are the expenses of plants in service and what are the expenses of construction? And that's why there's similar materials, but if they're being used quite differently, then one thing can be an annual transmission requirement, and the other is building up capital.
Well, I think in doing the equitable analysis, and this is in the nature of discordant. I think that regardless of where one thinks of those as very different, there has to be, if there was a finding by FERC that because we didn't report this correctly, there wasn't an audit that couldn't have been done, and they would have disallowed some of those expenses. Yeah, sure, we could have a different inquiry. But here they relied on what I would term some sort of perverse form of per se disgorgement, and there's no equitable principle that allows that. They really got to look at the substance. And I think there's two levels. One, are these as a category the kinds of materials and supplies that can be recovered? Undisputed that they are.
Once used for construction?
Sorry, Your Honor? Once
used for construction as opposed to operation and maintenance?
The way that it works, Your Honor, and you can find this at JA 356, which is them approving this going forward. And I'm just going to quote this directly. They said in approving this going forward that these were just and reasonable and consistent with commission precedent that allows materials and supplies assigned to construction to be included in the rate base prior to being assigned to specific construction projects and then transferred to accounts that are capitalized. This is Horn Book for policy, and it applies in the same way those prior 10 years as it does going forward.
Sorry, this is a Horn Book and maybe dumb question, but is there some basic rate making principle that would treat construction and maintenance costs differently? I would think maintenance costs are more likely to be just expensed in the current period, and construction costs you have to capitalize them.
I mean, yes. I mean, there's certainly a way that is done, and
that is how FERC does it.
Right, but there's no suggestion here that there was a different
but it's sort of. I guess I hadn't thought of this, but Judge Pillard's question takes on greater importance the more there's just this basic distinction within rate making between construction and maintenance.
So again,
and maintenance is more favorable. Classifying something as maintenance is more favorable to the utility, because you recover the costs immediately rather than over time.
I apologize. There is absolutely nothing in this record that would support that kind of distinction. Is that it would be more favorable? This we're obviously on an APA review. They have nothing.
That's why I asked you about how rate making works.
I think it works. I think it works differently for different utilities. But I would say that if your honors are concerned about that, if you all want to send it back to FERC for some limited review about whether it would have been $10 million rather than $11 million if we had classified it the other way, that wouldn't be a problem for us. We think it would cash out the same way. And I did want to talk about why our reading of the form was more reasonable, but I see I'm in my rebuttal time.
Let me just ask you, Mr. Salem, line 5 costs were not part of the filed rate until the rate was amended was it 2020?
That's right, Your Honor.
They weren't part of the file.
They were not part of, because we were reporting this the way that industry was in a standard manner reporting us, and I think a very reasonable interpretation of the form. And I think the other FERC's interpretation is just frankly unreasonable. And I don't want to eat up all my rebuttal time, but I would ask Your Honors to not overlook our argument that we really think that we made no error, that we think that Order 200 gave us the choice to do it our way or FERC's way. And FERC's argument that the way that they're wanting us to do it now under Duke Energy Progress is the only way is just contrary to what Order 200 said, which is that those filling out the form have the choice on the method of functionalization. That's the key word in Order 200, that we have the choice on the method.
Thank you. We'll give you a little bit of rebuttal time. Good morning, Ms. Chu.
Good morning, Your Honor. Good morning. May it please the court. Order 200 did not give utilities the choice to lump together all of their material for both construction and operations and maintenance. Your honors are correct that there is a distinction. And going back to 1982, the commission made clear that utilities need to report this information, that it was important for the commission to have the estimates of which amount of their materials are going to construction and which are going to their general everyday operations and maintenance.
If the materials and supplies had been properly reported on line 5, there's no risk that the utility would not ultimately be reimbursed in some way for its construction costs, or is there?
Well, going
not under the rate, but under some capitalization or?
I think, Your Honor, that this portion, if disallowed under their filed rate, would not be recovered. It was not recoverable under Ameren's filed rate at the times that are relevant for this case. Now, going forward, Ameren, of course, has revised its tariff.
And the commission had no problem with that.
That's correct, Your Honor. The commission had no problem with that. But with respect to the prior period, the commission followed its general refund policy, which has been expressed in many cases. It's been expressed in the Consolidated Edison case, which we cited in the orders, in the brief, in the Towns of Concord case, and in the commission precedent, Puget Sound. So the commission has this general refund policy that where there is a violation of the filed rate, as there was here, the commission grants full refunds. And that's because the commission, the utility here misreported these amounts. And so the commission did do, I understand, Judge Katsas, you were asking if, isn't this may appear to be somewhat hyper-technical,
right.
But I think it's not. As Your Honors were both pointing out, there are implications for rate making. Let me
can you just explain that to me? Because I had thought the purpose of this form was just to help the commission gather information for its planning purposes. The utilities objected that this was unclear, it'll be hard to characterize, and you said, yeah, that's right, but it still might be helpful to us, so do your best and we'll give you discretion. And that to me feels very different from the suggestion we had in the course of your friend's argument that there is this very basic distinction between construction and maintenance, and it would have made all the difference in the world as to how those costs are treated, capitalized or not, depending on which line they are put under. So which of those is the more accurate way of looking at things?
Right. So let me try to explain, Your Honor.
Okay.
Thank you for the question. You're correct that Form 1 is, this page of Form 1 is informational, but it's not just for the commission. And the commission pointed out in the refund rehearing order that this is part of a formal challenge. This case comes up as a formal challenge by a customer to a utility's annual update. And the formal challenge process, it's pretty iterative. As you may have noticed in the joint appendix, there are just pages and pages of inputs to the formula, just pages and pages of numbers. And so there's a lot of back and forth actually between the utility and the customer before the case comes to the commission. And there can be disputes as to what amounts are appropriately folded into the filed rate. So it's the information on page 227 is not just for the commission, it's also for the customer. And that's where the commission is making clear that the utility is on the burden that this is like a Section 205 filing, as the commission, as this court has found, actually. The formal challenge is somewhat similar to a Section 205 filing. That's the Northern Virginia case. So it's the burden is on the utility.
And there, in Ameren's brief, they refer to many other utilities who have, following Duke Energy, submitted amendments, and they suggest that many other utilities have completed Form 1 with a 0 on line 5. And so should we anticipate many cases from other utilities in a similar situation who are dealing with a similar overcharge?
I don't think so, Your Honor. I think I'm not aware of any cases that are, exactly on all fours with this. I'm not entirely sure, but I don't expect the court should anticipate a whole slew of cases along these lines. But I also want to point out that the commission made clear in the rehearing order that predecessor affiliates of Ameren were aware of this reporting requirement. So, this goes into the balancing of the equities. Ameren knew, as of, going back to 1982, Ameren knew that the commission wanted it to break out construction materials from materials that are used in maintenance. And let me give you the citation for the predecessor companies. That's at the rehearing order, paragraph 29, note 64, JA 727, 28.
How common is it, Ms. Chu, that a line rather than an account is treated differently under a formula rate?
Your Honor, I'm not sure. It's true for accounting purposes. My understanding is that it's for accounting purposes. There's no particular importance because all of these lines, they're in account 154 for materials and supplies. But that said, again, this is going back to the Duke Energy case, paragraph 22, which says that there are rate-making implications for where you report these lines. And Your Honors are right that generally construction materials they eventually are capitalized, and the
rate-making
expenses.
Specifically on the question of lines 5 versus 6 within account 154.
Right, both of those lines are in account 154.
No, I understand, but there is a rate-making consequence on that.
Right. Well, as you can see here, Your Honor, this formula rate did not fold in line 5, so there was a rate consequence. The formula rate draws from certain inputs from the FERC Form 1.
Where can we see that in the record? That the formula rate, the closest I get is in, I guess it's JA 832. But I wonder if it just, I am envisioning a formula, and I'm envisioning a box, a variable that's got a line reference, and that it's plugged in. It's certainly the way both parties have briefed it. It has a bit of that feeling, but I haven't actually been able to see something that corresponds to that understanding.
Oh, well, Your Honor, that was it, JA 832. It's a little hard to see, but it's line 27, where it says materials and supplies. And in the second column, it says 227.8.C and 0.16.C, which indicates that the input is page 227, lines 8C and line 16C. Line 16 is not at issue here. So that's
how about line 5? For example, plant and service above, in the middle of that very same page, has net plant and service, and it refers to transmission, and it seems to encompass lines 2 to line 8. There's a bunch of bracketed line series that would include line 5.
To be honest, Your Honor, I'm not sure what that is referring to, because this page, JA 832, in this second column, these are different pages in FERC Form 1. So you can see there's page 205, 207, 219. I'm not sure whether the net plant and service, I'm not sure which lines those are referring to. But I will say that the materials and supplies that we're talking about here, line 27 and column 2, that's what Ameren revised. Ameren revised that portion to add in 227.5 as an input. So going forward, line 5 costs are folded in. But going backward, FERC felt there's a violation of the formula rate here, and this is a formal challenge context where the utility is obligated to show its work, and here the customers had overpaid to the tune of $11 billion, and the commission felt that it was equitable to follow its general refund policy and order full refunds.
Judge Rogers, do you have questions?
If I do, I'll speak up.
All right, great. Thank you.
Thank you, Your Honors.
Thank you, Your Honors. I think I can clear up this issue that you were asking about, Judge Katsas. There would have been absolutely no rate implication from changing it from construction to maintenance. You can see it on the line that counsel just mentioned. The clearest way to look at it is on JA9.
I'm sorry, to the JA?
Yeah.
832?
Yes. Well, JA9 I think is clearer because it's in red line.
I'm sorry, where?
JA9 is clearer because it's in red line.
Okay. Okay.
So see the very last line there.
27?
Yeah, that's right. So you see the C, 5C is added there.
Right.
That's right. So it's calculated the same way. The math works out exactly the same. Is because the recovery here is for carrying costs, for keeping it in the warehouse, for buying it in advance. So the carrying cost to keep in the warehouse, maintenance related spools and towers is the same.
So in other words, FERC allowed you going forward not simply to recover line 5 in the abstract, but to put line 5 into, I'll just call it line 27 of your formula rate, and line 27 is treated however it's treated, but it picks up 5 and 6.
That's exactly right. And this is why this is the most trivial of ministerial errors, if there was an error, and we strongly dispute there was. FERC wouldn't have done anything differently. None of the customers would have done any differently. This is, again, unless this court is prepared to overrule Koch and Gulf, ministerial errors cannot lead to retroactive refunds, which are in the nature of a disgorgement. This court's case law holds it over and over again. They had no attempt to distinguish Koch, and for those reasons, I would ask honors to vacate the orders on review.
Thank you. The case is submitted.
Case number 21-5116, Monte Silver and Monte Silver Limited, an Israeli corporation, appellants, versus Internal Revenue Service et al. Mr. Zell for the appellants, Mr. Klimas for the appellants.
Good morning, Your Honors.
Morning, Mr. Zell. Proceed when you're ready.
May it please the Court. My name is Mark Zell, and I'm representing the appellants, Monte Silver and Monte Silver Limited, together with my colleague, Noam Schreiber. We're both here from our principal office in Jerusalem, Israel. Good morning, Your Honors. We'd like to reserve 3 minutes rebuttal. When Congress enacted the Regulatory Flexibility Act in 1980, it had a very clear purpose in mind, that is to require federal agencies across the board, including Treasury and IRS, to take into account during the rulemaking process the interests of small business, and particularly with respect to the issue of compliance costs. It's not, you won't find it in the codified version of the RFA, but you will find it in the preamble to the public law, which appeared Public Law 96-354, 94 Stat 1164, paragraph 3, which says, specifically that Congress was concerned about the impact of federal rulemaking on the compliance costs incurred by small businesses.
Mr. Zell, it would be helpful if you would focus on whether your clients have standing. And for my purposes in particular, whether a rule that you've challenged caused the harm that your client claimed.
Article 3 standing issue is, after all, the cardinal issue in this case. And our position here today, Your Honors, is that both Monte Silver and Silver Limited incurred actual injury, form of future injury, future compliance costs that would be a result of the application of the regulations at issue and challenged in this case. Now, I think it would be helpful to recognize that the regulations that are challenged in this case are a cluster of regulations. That's something that the RFA itself contemplated the agencies could do under 605C. This not only included the regulations under 965, which was the originating or the precipitating statutory provision that gave rise to this to the regulations at issue here, but also under Section 962, which and other sections, which are all combined. These all the amendments were combined into a single rulemaking, both in February of 2019. And what's the injury? The injury, as I said, Your Honors, is the future compliance costs. So it would be caused to the plaintiffs in this case by when they go to, as they have done, to take the actual distribution of earnings and profits in subsequent years. Now, it's true, as the government says, that the transition tax here was fully paid, but
the future compliance costs, as I understand the record, and correct me if I'm wrong, but the future compliance costs were not something that Mr. Silver alleged he was aware of at the outset of this suit?
Well, one I would say is that he was quite aware of the fact that 962 would result in future compliance costs. In fact, spent a great deal of time trying to persuade the agency during the rulemaking process about this fact. And that's something you won't find in the JA, Your Honors, but it is, you'll see reference to this in the part of the, I think it's at ECF. Let me just take it. CF 39.3, which the lower court did not allow us to supplement the administrative record. But Mr. Silver was aware that after all, he's a taxpayer, a tax lawyer, and he would have to be filing annual returns. And this is a closely held company of his. His law office in Israel, 100% owned. In order to survive and provide the expenses for his family and for himself, he would be taking actual dividends in the future.
Although, did the record show or the complaint that he had ever that Limited had ever issued a dividend previously? There's
nothing in the complaint that shows that he took a dividend prior to 2018, and the reason is that at that time, before the imposition of the transition tax, the TCJA, there wasn't any real reason for him to do so. He was able to provide for himself and for his family from the salary that he took from the Israeli law company.
And the declaration supporting the future injury for purposes of summary judgment, where evidence was called for, that declaration was filed in support of a motion for reconsideration, the 59E motion?
Well, Your Honor will note that several declarations were filed by Mr. Silver and the companies during the course of the litigation below. The last one was filed in connection with the motion for reconsideration, where after all the happenings and goings on in the district court, where I would note that the district court addressed this Article 3 standing issue, Your Honor, on 3 separate occasions, and each time applied a different standard. So it was kind of trying to deal with a moving goalpost type of situation. So when we got to the motion for reconsideration stage, he supplied a declaration which stated for the first time that he would be taking this distribution, this dividend, for the purposes of providing for his personal and family needs. And in fact,
he didn't. So I think I'm understanding correctly that he didn't, at the time he filed suit, have
Correct.
any expectation that he would be issuing, that Silver Limited would be issuing these dividends.
In his personal case, I mean, there's nothing in the record that would support that, but I did mention that he was quite aware of the impact of the 962 election on himself and other similarly situated small business owners abroad.
Of the statute, but the statute is not being challenged here. It's a regulation.
Statute is not being challenged. That is correct.
Right. So the fact that you might have been aware of implications of the statute doesn't suffice for purposes of standing to challenge the regulation under the regulatory
That's right.
flexibility.
Our focus is solely on the regulations. Regulations under 965 and 962.
So can you focus on what shows that the burdens that Mr. Silver has identified are attributable to the amendments to the 962 regulations that were finalized in 2019, to the incremental clarification offered at that time, as opposed to the underlying statute or prior rules?
A small businessman trying to figure out what the ramifications were of the statute, but through the regulations would only know about the provisions of the regulations that would allow him to take advantage of foreign tax credits or deductions after statute nullified that possibility. It was only through the regulations and through the regulation process. Indeed, 962, the amendments to 962, section 9, the regulations 1.962-1 through 3, all of those were the first place that a small businessman would know that she could take advantage of the foreign income tax deductions or credits to offset transition tax liability that was imposed under 1965. Only through the regulations, Your Honor. And that is exactly what Mr. Silver did in this case, both before and during the rulemaking process, and also during and afterwards, when he himself had to file his returns in order to calculate his transition tax. And when he realized at that time that he would be in the future required under the regulations now, under 962, which derive directly from the regulations under 965, he would have to go through this complicated process of not only making the election, but calculating each time in the future, for the foreseeable future, he would take an actual dividend distribution from earnings and profits of the Israeli company. And that was a regulatory catastrophe for him and for others like him. Because if you, as I assume you have, Your Honor, you've tried to read these regulations, they are truly impenetrable. And that is exactly the point. That's what this Regulatory Flexibility Act was initially enacted to do. And when Congress amended it in 1996 to create a new injury and a new set of remedies in order to put teeth into its mandate to the federal regulatory arena, including the Treasury and the IRS, what they said was, now you're not going to be able to walk away from this. And as you, the agencies, are not going to be able to walk away from your responsibilities under this statute. We're going to give small entities like Mr. Silver and the company the right to go into court to challenge your attempt to circumvent the RFA requirements.
So, Mr.
So-
Zell, I'm sorry to interrupt.
No,
Is
go
it
ahead.
fair to say that Congress, in enacting this statute, has called for a very difficult, complicated calculation in terms of the way it allows, it has the transition rule and then the implications of the transition rule treatment on the treatment of future dividends? That's a bit of a complicated requirement. And I mean, it's helpful as I hear you today, you're saying, and then given that that is a hard thing to do, but it's what the statute requires, the Regulatory Flexibility Act calls on the IRS to make sure that its regulations make that easy.
Exactly. That is what did not happen in this case. In fact, after 3 years, Mr. Silver and the company are still attempting to get the courts here to reach the merits of their complaint. That is, was the certification made under 605B a proper one, given the criteria? And when you actually look at the administrative record in this case and the kinds of things that the agency was saying, like foreign corporations can't be small entities, individuals can't be small entities don't own foreign businesses or foreign CFCs. Speaking as one who lives abroad and has not more than one of these myself, I can tell you that's absurd. But all that Silver and Silver Limited are asking in this case was simply, please take a look at what they've said.
So
they've been silent in that.
Was it not so much the complexity of the challenge rule itself, but again, its failure not only to explain and clarify what the statute requires, but to explain the existing rule?
Well, they needed to explain how this cluster of rules.
See, when you cluster, my first take on that is that that doesn't help you. Because to the extent that the compliance costs flow from the statute or from the pre-existing rule, that's not before us. That's not encompassed in your Regulatory Flexibility Act challenge.
The cluster regulations I'm talking about, Your Honor, the amendments to those regulations that Treasury promulgated in 2019.
What about the 2019 amendment? Can you point specifically?
Take a look, Your Honor, if you may. I'm going to repeat it to you from memory of Treasury Regulation 1.962-1. That's in the statutory appendix. You'll see.
You can give us a page type.
All right, 88.
Statutory appendix at 188 to the end, really. And there's also one regulation that's not in here. Okay, there's 3 regulations. The 2 that were amended are here. There's a third that wasn't amended, which is 962-3, which is also it actually deals specifically with the question of actual distributions from earnings and profits and under that section. But if you look at 1.962-1, you'll see one of the important, the critical decision or the critical change that was made in the application, in the regulations, something that the government continually, throughout its brief, described as minor and inconsequential, is over at 1.962-1B, A1A. And you'll see in little I, you'll see there for the first time.
Sorry, which page are you on?
Page 189, sorry, of the statutory addendum. The critical change that was made in the 962 regulations, by the way, these are regulations that hadn't been altered since 1965. And then suddenly, as a result of the transition tax, TCJA, Treasury changed them in a significant way by requiring for the first time, defining that subpart F income would now include for the first time section 965A inclusion amounts. Those are the amounts that were now becoming in as a result of the transition tax. So that regulatory amendment then is at the center of what I would call a cascade of regulatory changes that all center around 962, which allowed small businesses for the first time to be able to take and to offset their transition tax liability with foreign income tax credits or deductions.
Okay, so in the complaint and in the factual record, which for these purposes I take to be the declarations of Mr. Silver, is there any identification of the compliance costs relating not to the initial election, which is past conduct, but relating to the figuring out of the dividend?
Well, the declarations, you will see in the declarations specific statements that actual distributions are contemplated, they will be taken, and when they be taken, he will have compliance costs. I don't think, not even the government doesn't.
And that is where?
Well, let me show you. You look at the plaintiff's declaration, it's this in the JA at 107 to 112. You'll see one declaration in support of the memorandum in opposition to the government's motion for summary judgment. You'll see another one at JA 168 to 172, Your Honor.
And that's number 4. That's the one that came in on the Rule 59E.
Yeah.
And the particular language in declaration number 3 that you would rely on, which is 108.
It's at 108. Yeah, just a second. He starts with paragraph 4, paragraph 5. Also, if you look at our brief, we have discussed this at length. And I would also point out, Your Honor, as we deal with this Article 3 standing requirements, as we discuss both below and in the reply brief. Oh, I see my time is over. I'm parking over the red light. Sorry about that.
Can I just ask you this page that you pointed us towards on 89 is all interesting and such, but I don't see any of this in your briefs on the traceability point that Judge Pillard was asking you about. The treatment of it in the blue brief is wholly perfunctory, and the treatment of it in the reply brief is just quotes a paragraph from the district court and says the district court got it wrong. So, I mean, where have you traced the injury, tried to trace the injury of future compliance costs to the new regulations at any point before your presentation this morning?
Well, the first thing I would start off, Judge Katsas, is to say that the Silver and Silver Limited are the objects of these regulations. This court and the Supreme Court has stated on a number of occasions that when that is the case, the standard for showing Article 3 actual injury and the other elements is very low.
How would you, just on that, how would you respond in terms of whether Silver and Silver Limited are objects of the regulation? I mean, Silver isn't a small entity under the statute, and Limited isn't subject to these regulations because it's Silver who is the shareholder in the foreign corporation.
Well, the response I have, Judge Pillard, is that Silver is a small entity.
For real estate purposes unrelated to this case.
Not just real estate purposes. He meets the requirements of a small entity under the terms of the RFA, which in turn incorporates the definition of the Small Business Act. Government tries to argue that he's not an entity. And so it cites no authority whatsoever for that proposition for the first time in its brief here in this proceeding. But if you look at the dictionary definition for entity, you'll see, as this court has in a previous case, not an RFA case, but back in 1997 in the Allied Association of Alarm Services case, which is cited in our brief, they specifically talked about the definition of the term entity, which includes natural persons.
All right. All right, we have taken you over time with our questions, but we will give you a couple of minutes for rebuttal.
Thank you very much, Your Honor.
Morning, and is it Mr. Klimas?
Klimas.
Klimas.
Thank you, Your Honor. May it please the court, Jeff Klimas for the appellees. Your Honor started for questions with standing this morning, and we think the standing is dispositive of the merits portion of this case. I will start there. And I think that Your Honor correctly focused on traceability. For purposes of the Regulatory Flexibility Act, the question is the burdens and costs of compliance associated with the rule. Here are the challenge regulations at issue. That's tracked through section 603, 604, 605 of the Regulatory Flexibility Act. Which talks about the impact of the proposed rule on small entities, the projected reporting, record keeping, and other compliance requirements of the rule. If an agency certifies that a full-blown RFA analysis is not required, it talks about a certification that the rule will not have a significant economic impact on a substantial number of small entities. Here, and I want to make this clear, if Treasury tomorrow were to completely rescind regulations at issue, the 2019 package of regulations, it would not add to or decrease the compliance costs of Mr. Silver going forward. None of his future compliance costs are traceable to either the 965 regs or the amendments to the 962 regs. All those compliance costs are traceable to other sources. And we walk through in our briefing the different sources of compliance costs that Mr. Silver is complaining about. He talks about foreign tax credit account. That is traceable to section 902 and 960 of the Internal Revenue. He talks about dividends tainted and untainted by 962 elections. That's traceable to section 959 of the Internal Revenue, 962D, the statute, the Internal Revenue Code, and the pre-existing portions of the 962 regulations that have been on the books for decades. He talks about a bilateral tax treaty between the United States and Israel, which again, not traceable to the rules. He talks about this notion of qualified and non-qualified dividends, which is traceable to section 1H11B of the Internal Revenue Code. Again, not at issue. The complaint, the grievance that Mr. Silver has is not with the rule itself, because that does not impose any forward-looking burden or compliance costs on him. The complaint that he has, the issue that he has, the statutes themselves. And again, if these regulations were repealed tomorrow, you would have the same compliance costs going forward, not one iota of compliance costs are added by these particular regulations. This is not.
I somewhat heard him to be arguing this morning, and this wasn't how I took the argument in the brief, so that alone may be dispositive, but that his argument, in effect, was the statute calls for something pretty complicated that will be hard to effectuate. The pre-existing rules are not very user-friendly in terms of marking a path. My clients didn't have to worry about that because they never became subject to them until now. And at least it was incumbent on the service in promulgating its latest rule to give us a roadmap. And so his traceability argument, if I'm summarizing it correctly, is that the failure to make sense in the latest encounter with this rule under this provision is itself what's the source of his harm.
Yes, Your Honor. What's contemplated by review under the Regulatory Flexibility Act tracks review under the Administrative Procedure Act. What we're reviewing here is the final agency action, and specifically because of the statute of limitations requirement in 611 of the RFA, we're looking at final agency action that occurred within the past year. It's not looking at an agency's failure to act, it's looking at what the agency actually did. And when you look at what the agency actually did, you're looking at the incremental burden of that rule. You're looking at
you'd say that the sin of omission as opposed to commission is not cognizable. It's not what's at issue under the Regulatory Flexibility Act.
That's correct, Your Honor. If, for example, Treasury had promulgated no regulations whatsoever, it's hard to imagine that Mr. Silver would have a valid Regulatory Flexibility Act challenge.
Or had promulgated something, just to make it a little bit harder for you, had promulgated something that basically tracked the statute.
Sure, if we made it a parity regulation, if the regulation tracked word for word verbatim what the statute says, would there be a valid Regulatory Flexibility Act challenge when we say, well, look, there's no incremental burden that's being added by these regulations. It is literally reciting word for word what the statute does. And it's not an obligation that's imposed by the RFA or Treasury or any other agency to try to alleviate burdens that Congress deliberately imposed with the plain text of the statute. That's where we part company with other counsel insofar as we're saying, what is the relevant cost? What is the relevant burden? And we think it's clear on the Regulatory Flexibility Act that any incremental costs or compliance related to the final agency action rule, and there just isn't any incremental burden added by these particular regulations.
As a matter of the record, can we consider the dividend at all? And if not, why not?
So prior to summary judgment being granted, there was no evidence that Limited had ever issued Mr. Silver a dividend in the past. So 2012 all the way through 2020, no evidence that in those 8 years, a dividend had ever been issued. There was no evidence of a present or future intent that Mr. Silver would direct Limited to issue a dividend in the future. But at the summary judgment stage, at the time that this case was decided on the merits, there was no evidence of either past dividends, present intent to issue a dividend, future intent to issue a dividend. And so when he came in on reconsideration, the district court said he was too late. To the extent that this was evidence that he could have proffered earlier, it was foreclosed from raising that reconsideration. We cite this court's decision, Lidos, for that proposition. To the extent that these facts did not yet exist at the time of summary judgment and came into existence later, they were also not properly the subject of reconsideration. We cite National Anti-Hunger Coalition in our briefs for that proposition, this court's decision in that case. So there is a question of timing, and we want to be clear, the appellants have not separately challenged the court's holding on that point. The court said this was not timely raised. It's not usable. I'm declining to allow you to post-decision bring in this evidence that was not properly before the court. Not in their opening brief, not in their reply brief, do they address that part of the court's holding, and we think that it's waived. We think that they are stuck with that rule. There is, in addition to the merits question, there is a question about the issue. I'm happy to address that, although we don't think it's properly before the court and ripe at this time because there is pending supplemental briefing on that issue.
I guess we have to, if we rule in your favor on standing, we still have to consider the disclosure issue, including the question whether to reach it.
Your Honor, that's right. You say one way or the other, we are going to reach the 6103 disclosure protective order issue or not. But certainly that could be reserved for a later date, considering the fact that there are essentially two arguments for why this information shouldn't be public. One of which
6103 and Hubbard.
Right. 6103
is resolved. Hubbard is pending.
Exactly.
And neither of those is collateral to the other. Those are interrelated. so we can't take up, shouldn't take up that chunk,
Right.
even though the disclosure issues are collateral to the merits.
Precisely, right. Yeah, so the 6103 issue is a cannot disclose. The Hubbard factors are a should not disclose in effect. And to the government, it makes sense that those issues be considered together instead of seriatim, and potentially subsequent appellate.
So you're asking us to remand that?
We think that would be appropriate and save that issue for later.
Remand it or just not reach
Just not
it
address that
on,
at this time.
you call it right. I think it's probably
Correct.
finality, but on some threshold ground like that.
Correct. That it's just not properly before the court at this time until there's a final disposition of the protective issue.
Right. Yeah, not a final order. So the relief here is as you describe in your brief, and the only responses I read from the individual and the limited corporation is that this is too complicated. Namely, to pay whatever tax you owe and then file for a REMA fund. Is that right?
Yes, Your Honor. In terms of the Anti-Injunction Act issue, where we're saying that there is another remedy, another procedural vehicle for addressing Mr. Silver and Limited's concerns separate and apart from a freestanding RFA suit, that a refund suit would be an alternative remedy such that you wouldn't have to bring a suit to enjoin the enforcement of these statutes that impose taxes as well as these accompanying regulations that talk about the calculation of those taxes. I guess we don't agree.
I guess the only point I want to get on the record is that from your perspective, there is a remedy available to him, whether he properly raised in the instant complaint or in his briefs, some of these arguments that are being made today in response to Judge Pillard's questions.
Yes, Your Honor. So the argument that it's too complicated, and I think that you're right, that's the only real pushback that we're getting from the appellants in this case, that they think that a refund suit would be too complicated. That's not really the case.
Well, we don't need to decide that, do we? I mean, the point is whether the remedy is complicated or not. It's the standard remedy for people who challenge taxes.
That's correct, Your Honor. It's done as a matter of course, where someone will take a conservative position on an original tax return and then file an amended return that takes a more aggressive position. They'll pay the tax with the original return and then sue for a refund in conjunction with that amended return. And it's often done just as a matter of course in run-of-the-mill type of tax issues because it stops interest from accruing. And so there's a strategic advantage of doing it that way. This is done by tax practitioners all the time. File a tax return, pay the tax, file an amended return, claim a refund. The situation that was contemplated that was being pushed back against in Cohen was the notion that someone should run into court with a tax refund suit without exhausting administrative remedies.
Right.
The majority in Cohen pushed back and said, well, no. That's not the normal procedures. We think that's kind of a convoluted and extravagant remedy to come up with that hypothetical. That's the exact opposite of what we're suggesting that Mr. Silver should do, which is to follow to the letter the regulations and statutes governing tax refund claims and tax refunds.
Other questions? All right, thank you.
Thank you, Your Honor.
Mr. Zell, your time had expired, but we, as I mentioned, will afford you 2 minutes for rebuttal.
Very generous. A couple things. First of all, with regard to the wrongful disclosure issue under 6103, I'm now representing to the panel that Mr. Silver and his wife will abandon any right or privilege they may have under the inherent authority of the district court to control its docket. In other words, the Hubbard line of cases. That leaves this court free to make a decision one way or the other on whether or not the 6103 was violation.
Abandoning your Hubbard
We are abandoning the
objection,
Hubbard.
continuing to press 6103.
That is correct. Now, let me just also address the issue that your honors were pressing during my.
And you'll let the district court know.
We'll file a written confirmation to that effect. Yes, sir. Now, with respect to traceability, the district court actually got this correct during our argument on summary judgment. If it were not for section 965 and the regulations under 965, there would be no issue about 962 and the regulations under 960 and 962. That's a direct traceability argument. They are particularly under the lower standard of Article 3 standing a review that applies in an object of situation and in a procedural injury case. I realize with respect to procedural injury, only imminence and redressability are relaxed standards, but nevertheless, this is should be a very simple case in terms of Article 3 standing. And the primary problem that the district court had in this case was about the speculative nature of Mr. Silver's intention that he would have future compliance costs by reason of his actual distributions in the future. As we indicated in footnote 5 to our reply brief, he has taken the distribution. That's now we've crossed that threshold, and he's now going to have to, and as he has done, he'll have to go through the whole the complicated analysis under these regulations in order to determine whether or not he has to revise his or take into account the results of the
Mr. Zell, on this record, I noticed that he had now taken it, and it made me wonder whether any traceability that might have been established relating to an anticipated dividend is now moot, and we don't have any record evidence of an anticipated additional dividend. So in some ways, that complicates our consideration on this record.
Well, I anticipated this question, Your Honor, and it seems to me that if we go that route, small business owners like Mr. Silver will never have an opportunity to raise this kind of question.
Well, I think as you frame the case, the way to raise it would be at the outset to say, once the election is made, there will be compliance costs associated with periodic dividends, and for XYZ reasons, we anticipate definitely having dividends in the future. And that is not the way this issue comes to us.
I'm sorry to interrupt, Your Honor. That is exactly what I argued to the court on summary judgment. And the court said, well, I can't accept your statements because they're arguments of counsel. Well, this is a legal issue. What possible allegation could Mr. Silver have made other than what he did that I anticipate taking an actual distribution in the future? I see my time has expired again. Thank you, Your Honor.
Thank you, counsel, and thank you for traveling all the way here to make your argument. The case is submitted.